today I want you to come up close. I got some things I want to share with you about gentrification, which has become really a global phenomenon. And perhaps one of the most famous communities that has been assaulted and attacked by gentrification is Harlem. But they are gentrifying in Honolulu, they're gentrifying in Asia, they're gentrifying in Atlanta, Washington, D.C., Cincinnati, Ohio. Gentrification has become a method of very evil, but rich and wealthy, powerful people with lawyers and law degrees and other kinds of degrees and old money over the past 25 years or so to take the communities where poor people live and make them their own. And Harlem has been at the center of that. And what I want you to listen to today is some information that I gave out about court proceedings against the ATLAH World Missionary Church, because we are the flagship church now here in Harlem. We are the most prominent, most powerful, most visible, most meaningful, most active church in Harlem, if not all of New York City. And we are against gentrification, we're against same-sex marriages, and we're against the democratic, liberal, abortionist racism that is so prevalent. We're against the food stamps. We're against the destroying of men and families and throwing them into homeless shelters through the process of the Democrat, the liberal, if you will, ideology that the government owes everybody a living. We're against that. And as a result of that, we've made some pretty powerful enemies here in New York City. And gentrification in particular, that has brought literally billions of dollars, if not nearly $1 trillion of investments in predatory bankers into Harlem and also into Bed-Stuy and Fort Greene. And now they are afraid that my voice and the presence of our church can undo all of that investment and cause them to go away penniless. If you look at the investment that has taken place downtown Brooklyn on Flatbush Extension and in Fort Greene, all up on Lafayette and South Oxford and DeKalb, it is absolutely incredible. But what they've also done here in Harlem. I have a teaching, I have a legal presentation. Yeah, I want you to listen to this today. I'm not going to be talking about other politics today. And I want you to hear as I outline the legal foreclosure case that has been levied against us. And you can see and hear the fraud that is clear as the nose on your face, that this is a fraudulent, a conspiracy to try to take down the loudest voice perhaps in America against gentrification. There are a couple of things I need you to be able to do. First of all, to understand that process, you need to listen very carefully to the things I'm going to say. And then I want you to be ready to pray for us, because we're going to defeat. We're up against billions of dollars and influential people in high and influential places. And you need to understand that a large number of properties, churches, tenement buildings here in Harlem have been taken fraudulently, illegally through a foreclosure proceeding that the people that were attacked by the predatory lenders and foreclosure lawyers did not have the wit, the understanding, or the money to fight back against these monsters called gentrifiers. I want you to hear that. I'm going to explain it in the segment that's coming up on the Manning Report today. Also, I want you to be able to learn to pray for us. But I'm going to give a call for everybody. If you're in the New York area or if you're in the Philadelphia area and you can come. On the 17th of February, we're going to have a meeting here at the ATLAH World Missionary Church. If you've had your property foreclosed, if you've had your house, your business foreclosed, taken by the movement of gentrifiers that have moved in, bulldozed over businesses and houses and vacant lots, and you have been moved to the hinterlands and did not and could not fight against the courts, but you feel the sting of the gentrifiers and the foreclosure courts against you. I'm going to call for a meeting at 7 o'clock on the 17th of February of the year 2020. And everybody who's been robbed through the foreclosure court banking procedures, we're going to have a meeting and we're going to coalesce and we're going to come together and we're going to fight this monster. You can even come from Honolulu. You can come from Oklahoma. You can come from Dallas if you so choose. We're going to make this a national movement, and our church is going to be the national, if you will, poster church for this whole business. First of all, so I need you to pray for us. And then the meeting that will happen on the 17th, we need you to observe this message you're going to hear after this introduction and share it with other people who have been robbed of their properties. And then we can then maybe hold a march against City Hall. I want to be able to, right now the issue against us is water and sewer charges. And they've raised a $2 million bill against us for water and sewer. At some point, we want to hold a march against City Hall, carrying 100 toilets that you flush and stand in front of City Hall with those 100 toilets because they're asking us for $2 million for water and sewer charges to flush our toilets. All of this is important, that you listen to it and be ready to hear the call. Make sure that you sign up to be a part of our Facebook page. You can subscribe to us on YouTube and follow us on Twitter. All that information will come up on the screen, and so we can get that information out to you. Follow me on Twitter at James David Manning. Is it Dr. James David Manning on Twitter? On Twitter, follow me on Twitter at Dr. James D. Manning. Subscribe to us on the ATLAH Worldwide channel, and follow us on YouTube. And also friend us on Facebook. All that information will come up so you can stay tuned of all these announcements that happen. But we need to hold a march against City Hall, and we need to hold a meeting, a national meeting against gentrification and the robbing of people of their property and the destroying of lives and communities by the wealthy and the powerful. It must end, and it will end now. ATLAH, the ATLAH Church, the most powerful, recognizable voice of any church here in Harlem. They're trying to attack us and to destroy us. I'm going to take you now into a message that's already in progress that happened at our Open Rewards prayer meeting, where we laid out the case against us and what is happening with the court proceedings. Mr. Engineer, please roll that clip. What we want to do tonight in the Open Rewards prayer meeting is talk about our issues with the courts and foreclosure issues, and what we'd like to do is to explain to where we are at present, and perhaps throughout the process talk a little bit about how we were able to be successful in vacating the judgment going back a couple of years ago, and why we are at where we are at present, and what the city of New York, what we believe that's happening with the city of New York, the community, our church, etc. And I'd like to get started with explaining to you perhaps something that we've not explained as of yet about why we are opposing and what the plaintiffs or the Bank of Mellon is alleging that we owe them in terms of the amount of money and also interest. And I would like to ask if Mr. Engineer, if you could bring up the MTAG, yes, that tax lien payoff quote. This is an organization out in Pennsylvania that services tax liens for corporations, that mortgage companies, banks, etc. They are the servicer of an independent arbiter, and they are presently servicing the Mellon Bank regarding whatever might be a tax lien against us. Now, tax lien is a misnomer for us because ours is water and sewer charges, but for them it's all the same event. And this MTAG company started servicing the Mellon Bank, rather, not us, I think in the year 2015 or 2014. You'll hear that read in one of the briefs in just a moment. But I want to show you the charges that they have levied against us. Potentially there's fraud, certainly corruption, if not just blatant mistakes that we have demonstrated by our efforts of the City of New York Department of Finance, of what Department of Finance says about what this church potentially could have owed anyone, as opposed to what this servicing organization is now saying, and the Bank of Mellon that is suing us is relying upon these figures. Now, the numbers are very small, but you'll see there is a property information. And the property information on the opposite of that number is $2 million. Total amount due is $2,294,000. The lien amount sold was $595.54. The interest has been $2,137.48, and the fees due are $56,000. In the next column under the property information, you'll see the lien amount sold breakdown. The property amount was $55.54, and I'm not sure what that represents. The Department of Water, which is the origination of the charges against us, Department of Environmental Protection of Water and Sewer charges, that was sold back in 2002 was $36,662.36, and that was all we owed. Now, we've been to the Department of Environmental Protection. Bennett has been down and investigating at the Department of Finance that sold this lien. And the only records they have of us ever owing them any money whatsoever is the $36,000 for water and sewer charges. But there are other charges added here. Department of Finance, water. The Department of Finance does not have a water category. They're Department of Finance. But it says in the Department of Finance, we owe them $54,000. This number, I believe, originated from a dispute we had with the American Baptist churches going back 20 years ago that we later settled, where they put a lien against us. But they're now kind of putting this in the category of the Department of Finance water charges. I mean, on its face, it's ridiculous. And then there's the ERP, which is, I'm not sure exactly what that means. Then they've got other. It doesn't say other what? Other people, other not people, other buildings. $4,815.07 for other. It doesn't explain what that's for. And then it says noticing $51.04. Then there's a surcharge of $4,788.07. Surcharge for what reason? And then if you look at the interest breakdown, now according to the records at the Department of Finance, the city of New York, and we've been there and we've asked them, they only have records about the $36,000. We've been to the Department of Environmental Protection. They only have the records of us owing them $36,000. These other charges were either inserted fraudulently or by some criminal activity or by some mistake. And that's why we need to be vigilant in our fight. If you look at the interest breakdown, which is the third category under property information, it says the property interest was $15,000 and $15,076.32. Department of Water interest was $815,339.56. Department of Finance water interest was $0. Now think for just a second. If in the second column they got Department of Water, Department of Finance water at $54,000, yet when they get to the other interest breakdown, there's no interest on that $54,000. Does that make any sense to anybody? Doesn't make any sense at all. They're just throwing numbers against the wall, it appears to me. Then they got other interest. They didn't say what this interest come from. So effectively, if we owed the city of New York, which they said we did, owed them $36,000, and that's all that can be demonstrated from the city of New York that we owe them. And over the years, over the 17 years, the interest accumulated on that, on an erroneous interest calculation, is $815,000 is what we owe them in interest, right? From $36,000, it's almost ridiculous to think about that much interest on $36,000, but that's what they're charging. And then they got other interest, but they don't say where it originates. They don't say if it comes from some other charge. It doesn't say if we burn down the building. It doesn't say, it says $1,306,006 other interest. What other interest? Based on what? But these are the charges. And they give a total of $2,294,439.11 is what they say we owe them. but we don't pay taxes. We are tax exempt. We're fully tax exempt. There's not a problem there. There's no records. Ben has been down to as I said now for the fourth time. We've gone over this with the city of New York, who originated these charges, and all they have is $36,000. Where did these other charges come from? I have a theory, and I'm going to suggest where it came from. But I want you to know that's the fight and why it's important that we look at what's happening. Why is the city alleging all of these charges? And even the interest amount. Were we to owe these charges, the interest amount is not applicable to our condition and our situation. I want to read the most recent opposition paper that was submitted by our attorney, Mark Anderson, who through a month and a half ago, I submitted an offer to the Mellon Bank to make this go away. I would pay them a certain amount of money. Mark Anderson was the attorney that submitted that offer. Now, they haven't accepted it, but because there has been a summary judgment that was issued in June of 2019, where all of these charges, along with whatever our arguments had been argued with Stuart Shaw against these charges, were denied in a motion, and the judge presiding over that matter ruled in favor of the plaintiff, which is the Mellon Bank, saying that we owe this money I just read to you from this chart. So from the summary judgment for foreclosure, which is what they got, then there has to proceed a judgment of foreclosure and sale. Foreclosure is one thing, but a sale is something altogether different. So you have to go through certain steps in order to get to an actual selling and acquisition of a property. So Stuart Shaw resigned on us, and we'll talk to you more about him later. And so we hired Mark Anderson to represent us, through which we made an offer. Mark Anderson, in his opposition to not to the total brief that Stuart Shaw submitted and that Judge Bloof denied, he simply offered a motion based on this report, because this is the referee. This is what was submitted to the referee, who then says this is what we owe. So I want you to listen to the opposition that Mark Anderson submitted. It says Mark Anderson, an attorney, duly admitted. I don't have to read that. I think that it has the introduction, and it has the procedural and property history. And then it has the plaintiff's motion. Mark Anderson writes, the plaintiff's motion, meaning the Mellon Bank, should be denied as it is based on inadmissible hearsay. The report of the referee should be confirmed whenever the findings are substantially supported by the record. And the referee has clearly defined the issues and resolved the matters of credibility. Let me just state that because it reads it's a law, it reads funny. What he's saying here is that the referee's report should be clearly defined as having observed the information and has resolved that it is credible and that it is true. That's what's being said here. It doesn't sound like that. And then he cites several, if you will, several court precedents where this is happening with several banks, where the judges and courts have ruled in 1, 2, 3, 4, 5, 6, 7 different issues that you can't just submit something to the referee. Well, the bank submits a report to the referee looks at it and then approves it. It has to be clearly resolved and credible, is what Mark is saying here. Item number 7. Where a referee bases their calculations on inadmissible hearsay, and we'll understand why it's hearsay in just a moment, it is proper for the court to deny a plaintiff's application to confirm a referee's report and grant judgment of foreclosure and sale. And again, Mark is saying that the referee, if he based their calculation on inadmissible information, hearsay information, then the judge should not grant, the referee report should not be accepted, and the judge should not grant a foreclosure and sale. And he also gives, I think, a cite on that. where the records themselves are not provided to the referee. In other words, the referee that gave the ruling to go back to the court was not provided with any records. Just hearsay and a statement, an affidavit. And it says where the records themselves are not provided to the referee, they constitute inadmissible hearsay. Here, the referee's report, which is attached as Exhibit B, and the relevant portions of the affidavit of debt with attachments attached as Exhibit C, only indicates there were 3 pieces of documentary evidence introduced to the referee. Number 1 was a summons and complaint against us, then a notice of entry with a copy of a decision and order dated on June 18, 2019 by Judge Bluth. And then the third piece of information that the referee got, and the only other information, was an affidavit of debt by the bank. And then it says in bold letters here, if you'll see where the letter gets darker and bolder, it says nowhere in the referee's report is it indicated that the referee actually relied upon or was provided with information. They just got those 3 information, which are only just the beginning of the process. Then item number 9, furthermore, the current servicer has not been the servicer for the entirety of the instant action, thus creating even further issues. By the own admission of Matt Nims, an employee of the servicee of MTAG Services LLC, that MTAG only became the servicer of this alleged lien on or before February 28th, 2013, nearly 4 years after the commencement of the instant action. The prior services was Plymouth Park Tax Services, which is now going out of business. By admission in the agreement attachment to the NIMS affidavit at Exhibit C, Expand ceased its operation of tax lien services. Thus, the defendant's lien was transferred from Plymouth Tax Services to MTAG Servicing. However, the NIMS affidavit is completely devoid of any mention of the prior services record. In other words, when Plymouth Tax Services allegedly transferred, when they went out of business, they gave the lien to MTAG, they didn't give them the records that they had held from the beginning of the process. It's just they somehow, not out of the blue, they got the assignment, but no records. And they've been servicing it for 4 years. It has been held that while the affidavit attesting to the records and procedures of a prior servicer is not necessarily inadmissible, the spokesman for the current servicer must aver that he was personally familiar with the record-keeping practices and procedures of the prior loan servicers in order to lay a proper foundation. And then you got the Deutsche Bank and where this argument was made. Because when Plymouth Tax Services transferred to MTAG, they didn't give them the bookkeeping. They just gave them our name and the amount. And so the attorney is arguing here that you don't always have to have the full amount if the person that's given the information can testify that they were very familiar with the records, they were familiar with the process, they understood it clearly, and can document that and can demonstrate that. Matt Nims can't do that. And he stated in an affidavit before the court he couldn't do it. So therefore, whatever he's saying is inadmissible evidence. Mere referencing to the prior services servicing records, even where copies of the predicate notices were annexed, were found to be insufficient to demonstrate compliance with this section. And again, there is the Mellon Bank of New York versus Davis, in the same bank that is suing us, where the court ruled against the Bank of Mellon, New York on the same issue. The NIMS affidavit is devoid of any mention of familiarity whatsoever with the prior services records. And it is clearly inadmissible hearsay which cannot be relied upon. And so This is brief. It could have been better. If I had written it, I would have written a better one. I think I would have written a more thorough one. I would have done more research. I would have brought in more instance information from the history of this matter. But I think just with this small introduction here, you get the idea that the lawyer is saying and demonstrating unequivocally that the case is based on hearsay information. But beyond that, I would have also gone before the referee. Personally, I would have gone before the referee and gotten information and challenged the validity of this. Our attorney did not do that, and that's why I dismissed him on yesterday. But even with this, you can see something in the so-called wash is not clean. What I want to do at this time is that we have hired an appellate attorney. Now, law students will tell you there are litigators who actually go to court and they argue, they litigate, they stand before, and then there are appellate attorneys who just do appellate issues. They don't do litigation. And then there are attorneys that do all kinds of things: personal injury, criminal law, medical malpractice. Attorneys do all kinds of different things. They come in all different shapes and forms. We have sought out an attorney who only does appellate issues. And this attorney that we're now hired has been licensed in several states, including he has argued cases before the United States Supreme Court in Washington, D.C., along with cases in the 3rd and 4th Federal District of the Federal Court as well. And his name is Michael Confucione. And here is a draft, that's not the total brief. It is a draft that he sent to me last night, because we were in court on yesterday and I dismissed our attorney with consent before the judge. And the judge is going to make a decision, and most probably it's going to be adverse to us, even though our attorney said it's all hearsay. This judge does not like me very much. And under normal circumstances, under just a normal judge, and were I not loathed by so many people as a hate preacher, this case would have been dismissed. But Elder LaFleur was there. This woman goes off when she sees me. I've never seen a judge so out of control. Just at my presence, she goes crazy. But at any rate, that's the trial level of the issue. We're going to get a decision. It's probably not going to be a good one coming up shortly. In the appellate division, where we are appealing the initial decision by Judge Bluth, here is the brief and here is our argument for appeal. And of course, we have, again, the statement and the table of contents in this issue. And here is what the attorney Confucione sent me just for me to review late last night. It said, did the Supreme Court err in granting summary judgment for plaintiffs in this foreclosure action and dismissing as a matter of law defendants' objections on standing, prior pending action, latches, and equitable principles? This is a foreclosure action against the Bethel Community Baptist Church located at 36 West 123rd Street, a church that has been a fixture in the Harlem community for more than 63 years. It says 35 here. I gotta correct that. In addition to teaching scripture and providing spiritual guidance to its members, the church operates a school at the premises, runs a breakfast program, after-school program for the children of the community, and houses the homeless. The church is a not-for-profit religious corporation. It receives no financial support from the city, state, or any other governmental agencies. Now, you know, and we want the people to review this, we just made an offer for the Ethiopian issue of $100,000. We have served over 1 million meals here in the community, referencing what's being said here. And I don't know if the engineer have that. We put together a small promo of our service in the community of meals. I don't know if we have that promo. Mr. Engineer, just let that run for just a second, because there'll be people who don't know us that this case will be introduced to, need to know this about what we do. And then he goes on to write, the dispute over water and sewer charges, beginning around 1991, the church had an ongoing dispute with New York City Department of Environmental Protection over the church's exemption from water and sewer charges. The church maintained that it was exempt under the water exemption statute, according to Chapter 696 of the laws of 1887, as amended by Chapter 893 and 894 of the laws of 1980, which exempts religious organizations from water and sewer charges where the property is used exclusively for religious purposes. The Department of Environmental Protection argued that the exemption did not apply because units on the church property house school teachers and church administrators. Pastor Manning, for example, who lives in the church. The dispute continued throughout the 1990s into the early 2000s. Meanwhile, the city billed the disputed water and sewer charges to the church, and in 2002 sold a tax lien certificate to a private party rooted on the allegedly accrued and unpaid water and sewer charges. This led to the foreclosure action against the church, now at dispute in this appeal. The first foreclosure action, an Article 78 proceeding from 2003 to 2007. In 2003, a plaintiff named the 1999 Trust commenced a foreclosure action against the church in the Supreme Court of New York County under number index 104-110-203, seeking to foreclose on the basis that the 2002 lien certificate that the city had sold for the claimed unpaid water and sewer charges. In response, the church filed an Article 78 proceeding contesting the unpaid water and sewer charges as illegal under New York law, which exempted the church from the charges. The Article 78 Supreme Court stayed the foreclosure action, then in 2004 ruled for the church on this Article 78 petition, affirming that the church was exempt from the water and sewer charges, rejecting the city's argument. Now, in this segment here, it is clear that back in 2003, you might remember my getting up and saying, we beat the city, we beat them because they had moved the foreclosure action against us. We went to court. Jones was with us at that time. And the court ruled in our favor that we did not owe the charges and stayed the foreclosure action against us in that instance. And they ruled that the exemption did not, well, the city ruled that the exemption did not apply and that the water and sewer charges were owed. The court affirmed, rejecting the city's appeal. When we won in the Supreme Court, that's the lower court, the city said, we're going to take you to the appellate. So they appealed the decision. It went to the appellate court. The appellate court rejected the city's argument and held in our favor that we did not owe the money. And it reads as the court affirmed, rejecting the city's appeal and holding petitioner is entitled to an exemption from the payment of water and sewer charges pursuant to statute. Although the statute provides that the premises must be used exclusively for religious or educational purposes to qualify for the exemption, and there are residences within the petitioner's church, those residences are for the church administrator and a teacher employed by the church school, and thus are incidental to the main and exempt uses and purpose of the property. Accordingly, they do not owe the debt. Now, this has been from day one. You would think the city would have stopped there, right? Because what you just heard is absolutely true. This church is only used for, this is not a business, it's only used for not-for-profit purposes. We all know that. They won't accept that, the city. From 2002 to present. The Court of Appeals granted leave, however, to review and reserve, but only on procedural grounds, ruling that the respondent was improperly, being the city of New York, was improperly denied an opportunity to file an answer to the Article 78 petition, the case was remanded from the appellate court back to the lower Supreme Court here in the city of New York to provide an opportunity for the city of New York to respond against the Bethel Community Church. But we two courts so far have ruled in our favor. We don't owe the charges. The second foreclosure action was a reactivation of the Article 78 proceeding. Though the Court of Appeals had remanded the Article 78 case back to the Supreme Court to permit the Department of Environmental Protection an opportunity to file an answer, the Department of Environmental Protection never filed an answer or took any action upon remand. The plaintiff in the foreclosure action, which had been stayed by the Article 78 court, by stay that means that no action can be taken, you cannot go any further, it's stayed. Took no action either to dissolve the stay or to restore the foreclosure action, which remains stayed and unrestored to this day. In other words, when Judge Kibby Payne, and I'll get to that in just a moment, issued a stay, meaning that nothing can happen to this church based on what the city wants to do, back in 2004, that stay is still in effect. When the plaintiffs got ready to move, they ignored that court filing and started a brand new procedure because that previous procedure had ruled in our favor. So they technically moved the case to another court with another index number. To this very moment, there's a stay again from 2004 that has not been resolved. Instead, the plaintiff in a preceding foreclosure action purported to transfer its rights under the tax lien certificate to a second trust in yet another entity named NYCTL 2005, a trust which filed a new second foreclosure action in 2009 under the current index that we have right now. You see what they did? Because the other action was defeated for the same charges, for the same reason. The first action was defeated. They sold a lien to somebody else, and then somebody else sold it to someone else, and the someone else who bought it then started a new and independent action, notwithstanding that the first action is ruling. But that's what they're doing, and you need to know this. The Supreme Court characterized the plaintiff's transfer as transfer to itself, and that's what they did. This second foreclosure action against the church was premised on the same allegedly unpaid tax lien certificate as the first foreclosure action. The trust company then transferred its right to yet another entity in 1998. And the current plaintiff in this action, the church filed an answer to the second foreclosure complaint. The matter then sat for several years in the Supreme Court. It just sat there. Finally, 6 years later in 2015, the plaintiffs obtained a default summary judgment in the second foreclosure action. And this is the one that had us all stirred up a year or so ago. It sat for 6 years and nobody did anything. And a foreclosure sale of the church was scheduled for February in 2016. By order dated August 24, 2016, however, the Article 78 court, Justice Mendez restored the Article 78 proceeding that had been remanded by the court for appeals years before and vacated default, and plaintiffs had obtained in the second foreclosure action, granting leave to the church to file an amended answer to the foreclosure action. The church filed an amended answer in the foreclosure action on September 6 in 2016, contending once again that it is exempt from water and sewer taxes and therefore the tax lien is unenforceable, and inserting the following affidavit defenses. So far as you can see what happened. For 6 years they did nothing. Then in 2015 they woke up a sleeping dog. We then, with Stuart Shaw as our attorney, we answered that, and Judge Mendez vacated the judgment. But they didn't stop. They just didn't stop. And as for the second affirmative defense, prior actions pending, namely the Article 78 proceeding under Supreme Court Index number 103377, and a prior foreclosure action commenced on the Supreme Court Index 1041, And as for a third affirmative defense, plaintiffs is seeking to realize a return of 18% compound daily as usurious rate as applied in this case, a rate of interest not authorized by law. And this is another issue, even if we owed the money. And as for a fourth affirmative defense, plaintiff has acted inequitably and has unclean hands. Among other things, the bank failed to disclose the prior related cases to the court. In other words, they didn't tell them about all the other stuff going on. And commenced this action despite a stay of its prior foreclosure action based on the same tax lien. And as for a fifth affirmative defense, plaintiff is guilty of laches, waiting 7 years to commence this action in order to obtain an excessive amount of interest, making it impossible for the church to redeem. And as for a sixth affirmative defense, a public auction would be inequitable and prejudicial to the parties. And as for the seventh affirmative defense, the church is exempt from water and sewer taxes, and therefore the tax lien is unenforceable. And as for an eighth affirmative defense, the action was commenced by an improper party, the NYCTL 2005 Trust, who was never the holder of the tax lien certificate, and purported assignment of the tax lien certificate to the plaintiff, the NYCTL 1998 Trust, is defective and of no force and effect. Therefore, the plaintiffs do not have standing to maintain this action. And that's all true. And they're not denying it. The foreclosure action was stayed pending resolution of the Article 78 proceeding. In the 2007 Supreme Court Justice Mendez, departing from his prior decision, who gave us leave and vacated the original judgment, now making the decision of the Supreme Court and appellate courts in this case, ruled that the city and that the church owed the water and sewer charges levied against us. That's important that we understand this. This action started in 2002. We've been fighting because we're innocent. It's 2017. Two courts up to this date, over the past 15 years, have stated we don't owe the money. It wasn't until 2017 that Judge Mendez stated that we owe the money. So for 15 years, we didn't owe it. Plus, there was a stay. It's important that we remember that going forward. The petitioner failed to show entitlement to a mandatory water and sewer exemption for the entire property, including all the apartments. And in May 2019, this court affirmed the Supreme Court's ruling. The summary judgment decision in the foreclosure court, following the appellate division's May 2019 decision in the Article 78 case, the matter returned to the foreclosure court. Plaintiffs again requested summary judgment and dismissal of the church answer and affirmative defenses. The church opposed, contending, among other arguments, the plaintiff lacked standing, failed to pursue the already pending foreclosure action in 2003 that's still out there in the stratosphere, and was guilty of laches for delaying the case so many years and causing a windfall of interest at 18% compounded daily as a rate, making it impossible for the church to redeem what it once only owed us $36,000 contested water sewer charges. Supreme Court Justice Arlene Bloof granted plaintiffs' motion for summary judgment. Plaintiffs established standing to prosecute this case by detailing the chain of title of the tax lien, the court said. The court also declined to find that the doctrine of laches applied. Bethelite contributed to delaying this case by asking the court to wait for the related Article 78. In other words, they're saying, we're the reason why they waited so long. Proceeding to finalize. The fact is that the plaintiff obtained a judgment of foreclosure and sale in January 2016. The property would have been sold at auction if Bethelite had not sought to vacate the judgment. The court takes no issue with Bethelite's effort to get involved in the case, the court merely finds that the laches do not prevent the court from granting summary judgment when Bethelite contributed to the lengthy days in this matter. We did not, but the court ruled that we did. Now, that the first department, that's the appellate division, in the Article 78 proceeding, had ruled that the water and sewer charges are proper. The court finds that plaintiffs are entitled to summary judgment. There is no dispute that Bethelite failed to pay the charges and that Bethelite failed to raise the issue offset in opposition or its affirmative defenses. The court agreed with the church that it could not confirm the referee's 2015 report, however, appointing a new referee to perform a calculation of the amount due to plaintiffs. The church's appeal from the Supreme Court's June, it should be 18th, 2019 order granting summary judgment for plaintiffs is as follows. The Supreme Court erred in granting summary judgment for plaintiffs on the foreclosure action and dismissing it as a matter of law. The defendant's objection on standing, the prior pending action latches and core principles of equity. The proponent of a summary judgment motion must take prima facie showing of entitlement of judgment as a matter of law, tendering sufficient evidence to demonstrate the absence of any mystical issues. I think you get the idea of what's going on here. There's several more pages plus exhibits. So the summary judgment that we're arguing now, we were in court on yesterday, LaFleur and I dismissed Mark Anderson, who wrote the opposition based on hearsay, for several reasons. Number one was that I stated that the Judge Bluth in the summary judgment of June 18th stated that we had a right to appear before the referee to challenge these charges. And he never brought me before that. He denied us that right. He just didn't do it. Plus, he did not communicate with me. He did not ask me my advice. And he made several attempts to get me to settle with the bank, telling me that his wife is a banker, they'll provide a loan for us, et cetera, et cetera. I mean, I don't know who he thought he was dealing with, but he was very inconsiderate. Yesterday, on Friday, I sent him a notice. I don't know, we don't have the letter, do we, of the, that I sent? We do have it? Could we get that letter? I don't have a copy of it. I think, hello, Attorney Anderson. I'm writing to inform you as pastor of the Bethelite Community Church, we are no longer wish to retain you as our attorney. Please note that this dismissal is effective upon date of this email, 24th of January, 2020. For you and your court, court information, you have failed most egregiously to protect our rights to appear before the referee, as stated by Judge Bluth in her 18 June 2019 summary judgment decision. Moreover, your attention in this matter has been horrendously unprofessional and negligent. You did not answer my phone calls or emails over a period of 3 weeks, twice. I pleaded with you to advise the court that, number one, real property taxes in the referee's report were not true or valid. Number two, that the 18% interest only applies if we paid a minimum of $2,750 in real property taxes. We are and have been a tax-exempt, not-for-profit church recognized by the city and the state of New York. We pay no real property taxes. Therefore, the interest calculation is not applicable. Number three, we inform you and presented documentation indicating that several charges in the report were alien to our account. Specifically, the $1.3 million interest charge that had no origination in the $36,000 charge from the Department of Environmental Protection and the City of New York Department of Finance. We deserve our day in court to dispute these charges. You failed us. Judge Bluth stated that we had a right to appear before the referee. You did not protect that right. I ask that you make no effort to double cross us by entering in this matter any further. You are dismissed. Respectfully, James Manning. Now, the reason why I did that, as you can see, the reasons are clear. Though he submitted a partial defense, it was not the best defense based on hearsay. I could have written a better defense. Moreover, as you can see, he did not attend to this matter the way I thought he should have, so we have dismissed him. On yesterday, Judge Bluth, she didn't want to let him go because that means the matter has to be then stayed, and I need time to get another attorney, even though it's at a final stage now. She was really ticked off. She was heated. But after he explained to her that I definitely didn't want him as our attorney, she relented, and then she called for a conference there at the bench, and I came up and I consented before her. I didn't want him. He consented. He's okay with that. The plaintiff attorney consented, and she wrote a note explaining that he's no longer our attorney. But she's still going to rule on the case based on his submission, which I think could have been a better submission. She could rule in our favor. I don't think that she will. So we now have to have, in order to defend ourselves against her, if she rules against us, then we got to appeal her decision, and we have several ways to do so. Number one is that the decision of the referee was without our opportunity and our right. I had a right, and she ruled it herself, to appear before the referee. I was denied that right. So whatever she rules effectively can be vacated until my rights have been defended by a new attorney. That might take a little wrangling in the courts to get that done. But the other item, of course, is we can just appeal the whole process based on MTAG and the fact that they don't have records. I suspect that what happened when the bank went back to court and they discovered that Jones was not servicing us the way they just threw charges in, thinking that nobody, because like for 2 years, nobody appeared on our behalf. This matter stayed in the court for 2 years and nobody appeared on our behalf. So they figured, let's just put any charge in there and we'll just reap a windfall profit. They didn't expect us to show up. And now they've got these charges, they can't define them. They can't substantiate them. I'm telling you, how does the Department of Finance have water charges, as you saw in the opening statements I have? So it's a very nuanced case. What I'd like to be able to do, and I think our process will need, we have the appellate brief. What I read from Confucione just a moment ago is a brief that will be filed in the appellate court, not in Judge Bluth's court. Depending on what she says, we'll have to have a trial lawyer, a different lawyer file in her court, or have Confucione file in the appellate division. They have been running away from these charges of 18% interest. Stuart Shaw did a great job of acknowledging that they were not applicable to us. But the city and the plaintiffs, they just keep saying, but no, you owe them. And here's what happens. The city of New York will charge you 7 or 9% of interest, depending on whatever debt you have with them. And then they can sell that lien. And they allow the lien purchaser to charge you a large amount of interest, namely 18%, if at the same time you pay at least $2,750 in real property taxes. In other words, to qualify to be charged 18% interest, you have to also pay real property taxes. We've never paid a penny in real property taxes in 35 years because we're tax exempt. Yes. So therefore, you can't apply the 18%. The best you can apply is 9%, which greatly reduces the amount. But also, as you can see in the MTAG report, that those charges are bogus. I mean, the gall And this is what we've been fighting now. I've been fighting this for years. It's almost, but we're going to win. But people need to know this. I made an offer a couple of months ago, and I made a recent offer. I'll pay you the $36,000, and I'll pay you 9% interest from 2009, and that's it. The lawyer yesterday said they'll take it's up to 2.4 million. He said they'll take 1.8 or 1.9. You lost your mind? He said, what's a $500,000 deduction? I said, boy, you're crazy. You know that? Are you? That boy. And I think Elder LaFleur acutely observed that Mark Anderson, though he's been practicing law for 20 years, he's very young. He came in yesterday with like a summer suit on and a pair of orange shoes that you would wear in Miami. He looked like a Miami Vice guy. You don't go to court looking like that. You wear dark colors, blue, gray, you're going to court. He's just very young. There's this article here that I want to put forward, and then we can have our time of prayer. But I wanted everybody to know where we are. We still have some fighting to do. I have a recourse I'm going to take, but I don't want to publicly broadcast it because I don't want the devil to know what we're going to do. But the appellate courts and fighting this requires of us, just having the energy to do it. I don't mind doing it. It's just a matter of finding lawyers. I'm telling you, Kenneth Folk used to be Bennett's mother's pastor. Kenneth Folk told me years ago, he was from Jamaica. He said, he talking to a West Indian accent. He said, you go talk to a lawyer, your church, watch yourself. You come in as a church, they put on a pot. By that I mean, they know that they can suck you for all the money they can suck you for and still don't help you. And you don't know the law. So we've gone through several lawyers now and several thousands of dollars trying to get this matter resolved. We will. And I think that even as it is, we're doing a great job of fighting. And I'll tell you what we're going to do in just a moment when I shut down the cameras. But I want to, I think someone brought this to my attention the other day about a church, the Gospel Missionary Baptist Church, that was foreclosed on and they lost their property. A storied Harlem church held its final service in Manhattan the day before Martin Luther King Jr. Day after it lost a court battle to keep its basement space on West 149th Street. The Gospel Missionary Baptist Church was booted from the West 149th Street Riverside Drive after a foreclosure sale, despite more than 2 decades in the neighborhood. A trustee at the church, Kimberly Correlia, said worshipers held their last service on Sunday with Reverend Dr. James Wilson urged them to keep the faith. We were bamboozled, Correlia, the daughter of the Gospel Missionary founding pastor, Bishop Henry Smalls. I knew Bishop Smalls. He was my friend. He was Evangelist Ruth Brown's pastor, at least very close. She was with him in that church for years down at Second Canaan. Dr. Latson, who signed my ordination certificate, brought Henry Smalls to my ordination certificate. And we knew one another. He invited, when Dr. Latson died, he was like a son of the church. And they should have elected him as pastor. I think they did, but they wanted to fight him. They did to him what they tried to do to me. They wanted to have the bus rides. They wanted to sell the tickets. And he wouldn't let them do it. He said, no, we're going to tithe it. And they put him out, which they tried to do to me too. But I survived. So because I survived, he called me. He had to take some members out the church, what they call split the church, moved up to 149th Street and started a church up there himself. I knew him. He was South Carolina, good man, good preacher. I haven't had contact with him as I hadn't had contact with a number of Baptist pastors. But they did him wrong. Now, ironically, the Second Canaan Baptist Church is now under the same circumstance as the Gospel Missionary Baptist Church. In other words, they got a first floor storefront down here on Lenox Avenue. The same way Bishop Smalls. I mean, if Dr. Latson see what these people have done to his ministry and the hard work that he put into building that church, I mean, he would literally scream and ask me, why am I not doing anything? My other question is, Bishop Smalls is dead. He died a couple of years ago. So someone's running the church. I'm not sure whether it was his daughter. They alleged that they didn't know that they had to pay. What's those charges they have to pay? Maintenance charges. It sounds pretty dumb to me, but trust me, church people can make some dumb moves. And they didn't pay them, so the apartment owner foreclosed on them. But even if they didn't pay them, if they had a lawyer, they could go to court and stop the action. Say, well, we will pay. I mean, how much could they have owed? So without good counsel and good advice, you know, and the other thing is that the owner of the building wanted the property. He wanted them out of there in the first place. You know that they do, like they want us out of here. But and Dr. Wilson, James Wilson, I know him too. You would think they would have, Pastor Manor, what do you think about this? You survived the foreclosure. We've heard about you in the news. You think one of them would have asked me for some counsel? I'm not trying to make myself all that, but I could have helped them. I could have showed them how to save their church. They didn't have to be put out. Anyway, I guess they wanted to ask Obama. I guess he didn't come. They're waiting on Obama to come save them. Boy didn't show up. I think it's important that we have heard here tonight. I pray this has not been boring to you, that you see this and that you know this, and that you know the details of the case. We're going to continue to fight, and we believe that God will give us ultimately the victory in this matter. This is a bit of a news blog we do, looking at spiritual wickedness in high places for the most part, making some observations about it and giving people a biblical foundation to the way of interpreting, rather than have Sean Hannity or Laura Ingraham or Janine Pirro or Anderson Cooper or Rachel Maddow or Don Lemon, Rush Limbaugh interpret what's going on in the world. You come to me and I'll tell you based on what the Word of God says. They'll just give you their worldly, sinful view. But the Manning Report will tell you what God has said, whether to say yea or nay, whether to go or to stay. You'll be led by the word of Almighty God. Come to the Manning Report on a daily basis to interpret the spiritual wickedness in high places, because there's plenty of it that's going on. And so I am he. I'm the Lord's servant, James David Righteous Rebel Manning, and I'm here to serve you with news and information.